come to order. We have several items on today's agenda. We'll vote on 4 judicial nominees. We'll also vote on S. 1979, Protecting Older Americans Act, sponsored by Senators Gillibrand, Ranking Member Graham, 12 other senators from the committee, including Senators Grassley, Padilla, Hawley, Blumenthal, Booker, Ossoff, Coons, Butler, Whitehouse, Hirono, and myself. Senator Kennedy has to go to another meeting. It's asked for 2 minutes.
Yes, sir.
Start the clock.
Thank you, Mr. Chairman, and thank you for your courtesy. I have to go to another committee, and I wanted to just make a quick comment about Senator Gillibrand's and Senator Graham's Protecting Older Americans Act. I've really struggled with this bill. I believe in access to our courts. I plan today to vote to get the bill out of committee with 2 caveats. Number one, that's assuming we don't screw it up with some bad amendments. I understand that bad is subjective, but the second, I reserve the right to vote no later on the floor. I don't like contracts of adhesion. There's a reason that the common law and many civil law jurisdictions prohibit them. On the other hand, I believe in the freedom to contract. And there's a delicate balance here. I think the Senate is smart enough to find that balance. I'm not sure we have the balance in this bill, but it's a start. So I'm going to vote yes today to get the bill out of the committee, subject to the condition that if we screw it up with amendments, I'm going to be a no. And if and I may be a no on the floor. And I thank the chairman for his indulgence in letting me do this. And I heard Senator Whitehouse's snide comment, by the way, to you. So I
What,
think
me?
I did it. I think I did it within the 2 minutes.
It is a constant patter I hear in my left ear. With that, I'll turn to
There's a
ranking.
place in heaven for you, Senator, automatically.
With that, I'll
Right by
turn
you.
to Ranking Member Graham for any opening remarks.
Well, number one, Senator Kennedy, I understand exactly what you're saying. What are we trying to do here? America is aging. I would hate to be fired because of my age or believe that I was fired because I've just aged out and they can hire somebody younger to save money. So arbitration is one-sided in situations like this, in my view. So I don't want to lock people into arbitration where the playing field's not level. If you believe you have a claim, you've been denied your employment or opportunities because of your age, I want to open up the courtroom to you. You still have to prove your case. The burden is on you by the preponderance of evidence in a civil matter. And the company in question or the people in question will have a robust defense. So it's not like we're determining the outcome. We're creating a process that I think is more fair. I'll end where I began. More and more Americans are getting older. Our population is aging. And we're going to need as many people in the workforce as long as reasonably possible to keep our economy going. And that's why I'm for this bill.
After considering nominations, we'll go to the bill and see if there are any amendments. And we want to thank the ageless Gretchen Carlson for being here today and inspiring a lot of the effort.
Speaking of ageless, I want to thank Senator Grassley for
what a comparison.
helping me get this thing moving. And he's had a midlife crisis. And he's going to solve it right here in front of us, and we're going to get this bill over the line.
That is regular order for sure. We turn to the votes on nominations. The first is Kevin Ritz, nominated to the Sixth Circuit Court of Appeals. I'd like to briefly comment on his nomination. During the hearing, members of the committee questioned him about a complaint submitted to the Department of Justice Office of Professional Responsibility in connection with his representation of a case. Mr. Ritz has stated that he was not aware of the complaint. In fact, he reiterated under repeated questioning by members of the committee. One member even went so far as to accuse Mr. Ritz of lying to the committee. As I mentioned yesterday, that would be a federal crime when you're under oath. No evidence was produced to suggest he was lying. In fact, this accusation was untrue, unfounded, and wholly inappropriate. Here are the facts, as Mr. Ritz explained at the hearing and as we followed up to find to be true. He did not receive notice from the Office of Professional Responsibility regarding any letter of complaint. This is presumably because OPR determined the complaint was meritless and dismissed it. As OPR itself says on its website, and I quote, "Most complaints received by OPR are determined not to warrant further review because, for example, the complaint on its face appears to be without merit or is unsupported by any evidence." This is the most important sentence. In such cases, OPR will close the matter without informing the subject attorney of the complaint. Notably, the defense attorney represented to the court during the case in question that she was not accusing Mr. Ritz of any misconduct. In fact, no allegations of misconduct against Mr. Ritz were ever substantiated. The judge in this case stated, and I quote, "The record does not reflect a determination by the court adverse in any way to Mr. Ritz. I need that to be absolutely clear," the judge said. Given these facts, the treatment of Mr. Ritz by some members of the committee was disappointing. His nomination to be U.S. Attorney was voice voted out of this committee in 2022. Notably, he enjoyed the strong support of his home state senators at the time. Does anyone seek recognition to speak on Mr. Ritz's nomination?
Mr. Chairman.
Senator Blackburn.
Thank you, and I'm not going to take up the committee's time today to rehash the White House's history of not working with Senator Hagerty and I on these judicial nominees, but I do want to say this. The White House rushed through a backroom deal to put Kevin Ritz in this seat, and by so doing, they have nominated a man whose lack of professional ethics unquestionably disqualifies him from federal judicial service. And for all of my colleagues on the other side of the aisle who care about indigent criminal defendants, who care about preserving criminal defendants' constitutional rights, and who care about supporting our federal public defenders, you should be very concerned by the prospect of Mr. Ritz serving as a federal judge. I know that my Democratic colleagues believe in the American ideal that every individual accused of a crime is entitled to due process of the law. But that's not how Kevin Ritz operates as a prosecutor. Mr. Ritz uses bait-and-switch tactics to trick indigent criminal defendants into accepting plea deals they didn't agree to. He leaves his written plea agreements intentionally vague, lures indigent criminal defendants and public defenders into an oral agreement, and then pulls the rug out from under them in court. And when a female defense attorney finally called Mr. Ritz out on his unethical conduct, he tried to defame and discredit her. In fact, Mr. Ritz was removed from that case because of his unethical behavior. The prosecutor who replaced him went so far as to say on the record that the allegations of Mr. Ritz's professional conduct, and I quote, are serious and are taken so seriously by our office that Mr. Ritz will be taken off the case, end quote. And this wasn't just one case. Mr. Ritz's reputation for unethical behavior is well known across the Tennessee bar. Just ask Stephen Shankman, the former federal public defender for the Western District of Tennessee. Mr. Ritz's ethical misdeeds are so well known that when Mr. Shankman first heard reports of a prosecutor behaving unethically, he knew it had to be Kevin Ritz. In an email warning other defense attorneys about Mr. Ritz, Mr. Shankman said, and I quote, "This is not the first, second, third, or whatever occasion that this sort of thing has occurred, but everyone should be aware of this unfortunate pattern of behavior. You should be aware, your clients should be aware, and you should proceed with extreme caution," end quote. You should proceed with extreme caution. I'd like my colleagues across the aisle to think about that one. Is that how you want indigent criminal defendants and public defenders to feel when they enter an American courtroom and Mr. Ritz is the presiding judge. I would hope you do not want that. Mr. Ritz has a history, unfortunately, of lying to the federal courts, lying to federal public defenders, and lying to indigent criminal defendants. And during his confirmation hearing, Mr. Ritz lied to the committee. Mr. Chairman, I do not believe that Mr. Ritz has the judgment or professional ethics to be a federal judge. It is deeply, deeply disappointing to me. We had asked to work with the White House. We know what has transpired here, and I hope my colleagues across the aisle who are concerned about unethical federal prosecutors trampling on defendants' constitutional rights will join me in opposing this nomination.
Thank you, Senator Blackburn. Before recognizing Senator Tillis, I would like to make this point. The committee has received many letters of support for Ritz's nomination, including members of the defense bar in Tennessee. I want my colleagues to listen to this one sentence. One letter from the federal defender of the Western District of Tennessee said of Mr. Ritz, I quote, a fair person of integrity, and notice his, quote, perfect temperament to serve as a judicial officer. That comes from the federal defender in Western District of Tennessee. Another letter from a criminal defense attorney who served as opposing counsel in cases with Ritz described him as, quote, intelligent, honest, hardworking, and fair. Before we make allegations of any witness before us lying to this committee, recall that they are under oath and that would involve possible criminal action. I would be very careful in using that term myself. Senator Tillis.
Thank you, Mr. Chair. I have a great affinity for Tennessee because that's where a lot of my family lives. I went to high school in North Carolina, tried to get it admitted to the Union as North Carolina, but we had to cede that territory. So I got a big connection to Tennessee. And I just want everybody to recognize why we're having this discussion right now, because we nuked the blue slip on circuit judges. And now we've got two Republican members who absolutely do not like this nominee. I'm not even going to get into the argument. I'm sympathetic to a lot of what Senator Blackburn said, but we are here because we have politicized circuit court nominations. And I don't believe the White House has treated Senator Blackburn and Senator Hagerty with the respect they deserve. Of course we have a Democrat president. Of course we just should assume it's going to be a Democrat nominee. But honestly, is this the only one the White House can come up with? And the reason why I'm a little bit sympathetic to it is I had the White House try to tell me they were going to jam me on a circuit court nominee for the Fourth Circuit. They made the mistake of being definitive about how they were going to dictate the process until I told them. I walked across the aisle and I got Democrats to commit to me that they would not confirm their nominee, that they were going to try to shove down my throat. I've tried to keep that private, but I'm trying to explain to my colleagues, folks, if you want to work on a bipartisan basis, do it when it's hard. Go back and tell, if you want to be bipartisan, do it when it's hard. Go back to the White House and say, how on earth can you have two members from Tennessee objecting to this? Now, this member is going to get out of this committee. Next year, we may have a different president, and we may have a president who's not currently in office, and that president may choose to shove down the throats members in your circuits later on. Remember this moment. You can still get angry, but remember at this moment in time when you cast this vote, you're guilty of the same behavior you're going to accuse some of these folks being guilty of a year from now. Thank you, Mr. Chair.
Mr. Chairman, I yield to my more senior senator.
I was just going to speak from the seat on this committee occupied by Senator Feinstein, because as I sit in this chair, I remember her sitting here and describing her fury that not only was a circuit judge being shoved down her throat because of the lack of a blue slip rule, but she didn't even believe that the nominee was from California. So this problem goes back to a determination made by Republicans that blue slips would not be honored for circuit nominees. I'm more than happy to consider trying to undo that and figure out a way to go forward. But a lot of us got burned hard by that rules change and the disrespect to us on this side as senators that was shown in the aftermath of that rules change.
Sir Whitehouse, I agree, but can we all agree that that fuse got lit when Senator Reid nuked the filibuster for Supreme Court nominees?
No, I think the blue slip is a completely different thing.
Oh, okay.
Senator Booker?
Thank you, Mr. Chairman. I understand and actually feel the anger and the fury of Senator Tillis, and I think it's justified. And I hear Senator Blackburn, and I don't need to hearken to a member, God rest her soul. This happened to me under the Trump administration. A Third Circuit judge was shoved down our throat that we didn't even have a chance to meet with or engage with, and we thought we were negotiating in good faith for a large picture that included district court judges, but then we were told that our opinions didn't matter. And so I'm not looking at the providence of how we got here. This is situations where people feel justified injuries on both sides. I just suggest to members who feel the same passion as I do, and as I think Senator Tillis does, that we could sit here and curse the darkness or point fingers at who caused it. But I'm happy to meet with anybody that wants to try to figure out a way out of this mess, because I think what my colleagues are pointing out on the other side of the dais is absolutely right. This is wrong, and I believe we should get back to where we were before.
Senator Lee?
Thank you, Mr. Chairman. Wanted to echo my concerns to those who have spoken already with regard to their concerns with this judge. I want to raise a related matter, a matter that came up at his confirmation hearing that I asked him about in the hearing and didn't really get satisfactory answers, so I asked him more specifically and more clearly, I thought, and the questions considered for the record. One of those questions, question 37, I asked him the following. Knowing that Ms. Taylor Fondren had been accused of intentionally withholding exculpatory evidence from the defendant and making false representations to the court, did you have any conversation with her about those allegations? Were the two separate investigations into her conduct a factor in your decision to elevate her to serve as your first assistant? Remember, when someone serves as a U.S. attorney, the single most important and impactful hiring decision that person must make is to decide who's going to be the first assistant. The first assistant steps in the absence of a U.S. attorney and really does a substantial job in running the office. So it would not be an insignificant thing to appoint someone who had multiple complaints of violating Brady, withholding exculpatory evidence from counsel to the defense during a criminal trial. It would be an unusual thing to put in a first assistant who would have multiple complaints unresolved over that and not at least talked about it. His response was, as far as I can tell, utterly information-free. It contained words. The words referred sort of to the subject matter at hand, but were in no way, shape, or form responsive to my question. Instead, he says, Ms. Fondren is a native of Memphis who has worked in public service with the U.S. Department of Justice for her entire career. She began her career as Presidential Management Fellow with the Drug Enforcement Administration. It goes on, most of it's travelogue. Fast forward toward the end, and the next paragraph. At the time, I appointed Ms. Fondren to be the first Assistant U.S. Attorney in October 2022. I understood that the matter that ultimately led to the 2023 D.C. Court of Appeals decision in her case was still being litigated. It's not responsive to the question either. In response to questions I asked, including questions similar to those that Senator Blackburn discussed a moment ago, and those that those other questions that I asked related to cue for number 37 in my list of questions submitted to him, I found him to be, at best, non-cooperative as a witness. I also found some of his answers to be not entirely forthcoming, or at least responsive to what we were asking. That is concerning to me, in addition to all the other reasons that have been stated. I intend to vote no.
Thank you, Senator Lee. I just want the members to realize one or two things. One is I have worked with Senator Graham in a bipartisan way to preserve the blue slip for district court judges. There's been pressure on me and others to change that, some from friends and some from those who are not friends. But I still believe it is a valuable tool for the appointment of district court judges. And I thank the Republicans on this side particularly, and others in the chamber for working on a bipartisan basis to make the blue slip work under a president of a different political party. If we are going to do anything and blue slips on circuit court judges, I think there's one premise. We should do it prospectively, not knowing the outcome of an election that may change the presidency and may not. That is a fair way to approach it. If there's any member of the committee who wants to start an active conversation along those lines, I'd be glad to join it.
Mr. Chair, I want to be clear. I thank you for that, because I think you have been good on that. The only point is, folks, this is an opportunity to say the White House needs to do its homework. You don't have to have Senator Blackburn and Senator Hagerty having rave reviews over it, but you could argue that the level of their emotion right now justifies another look at this nominee. And I just apologize in advance, colleagues, next year, if we're in the majority and there is a Republican in the White House, after you are so frustrated with the circuit nomination that you're almost likely going to have confirmed, remember this moment. Being bipartisan when it's hard is what I'm looking for. Not judging this individual, but missing this opportunity right now. And I want to be technically correct that Senator Reid started something that Leader McConnell finished on judicial nominations. We all know that, but they're intrinsically linked. This is a moment for next year, if the tables are turned, to remind me, Tom, you remember when I voted against a nominee because this member was not treated with respect on judiciary? Then you can count me in to vote against the circuit nominee if you're treated the same way. But if you go down this path and you say, well, let's get together and sort it out, no, it's not about that. It's about a decision you're about to make. And if you make this decision, somebody who's tried to develop a reputation for working you all and voting on about as many nominees out of here as Lindsey Graham, maybe even more, including a district judge last week for the state of Illinois, just remember this moment. Because you won't be able to have the moral high ground to stand on to say, I should support opposing that nominee. Thank you, Mr. Chair.
Mr. Chairman,
Senator Blackburn.
to your point about working in a bipartisan and constructive manner, Senator Hagerty and I have done that. We did it on the first nominee that came up. We did it on this nominee. We gave the White House a list of names of Democrats who were qualified, who sought to serve. We sent those forward to them. The White House did not extend the courtesy of working through that list of nominees. As I said, from what we have heard from many different individuals, there was a deal that was cut that this would be the nominee. This is, and Senator Hagerty and I gave him the benefit of the doubt.
Senator, I recognized you and was very flexible in timing, but we should bring this to a vote. We know how you feel. I respect how you feel. I can't change how you feel.
Mr. Chairman, I think it speaks to the way the committee moves forward on these things, and Senator Tillis is correct. Senator Lee is correct in his questions and the vague response on the QFRs.
On favorably reporting the nomination of Kevin Ritz to be U.S. Circuit Judge for the Sixth Circuit, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Mr. Chairman, can I be heard on this after we conclude the vote? Aye.
Mr. Blumenthal.
Aye.
Ms. Hirota. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn. Mr. Lee. Mr. Cruz.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis. Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Senator Coons.
Thank you, Mr. Chairman. My very capable counsel has been trying to get me up to speed on the background of all of this. I apologize to you, Senator Blackburn, that I did not dig into this and talk to you before this vote today. I will not vote for this nominee on the floor until I have a chance to meet with you and to meet with White House counsel and review what's actually happened here and what's going on.
Senator Graham.
I didn't say anything because I couldn't say it better. So I'm not going to make that a habit, though. Bottom line is what Marsha and Tom are saying is, I vote almost yes most of the time, not, like a lot. This was an easy no for me. Just remember that.
I would say I'm ready to open this conversation and dialogue on a bipartisan basis if we're talking about a prospective change after the election. I think that is the only fair way to approach it since we don't know the outcome, what the outcome will be. And we have preserved the blue slip for district court judges, and if we want to expand it to circuit court judges, let's have that conversation. But the feelings that you have, Senator Tillis and Senator Blackburn as well, have been reflected on our side by Senator Whitehouse. I remember Senator Feinstein beside herself over a nominee for circuit judge and the fact that it affected the state of California. So if anyone wants to initiate that conversation, count me in, as someone would say. Next is Brian Murphy, nominated to the U.S. District Court for the District of Massachusetts. Does anyone wish to speak on his nomination? On favorably reporting the nomination of Brian Edward Murphy to be U.S. District Judge for the District of Massachusetts, the clerk will call the roll.
Mr. Whitehouse.
Aye.
The nomination will be favorably reported to the floor. Next is Judge Rebecca Pennell, nominated to the U.S. District Court for the Eastern District of Washington. Does anyone seek recognition on this nomination? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal. Aye. Ms. Arono. Mr. Booker. Aye. Mr. Padilla.
Aye.
Nomination will be favorably reported to the floor. Next is Jeanette Vargas, nominated to the U.S. District Court for the Southern District of New York. Does anyone seek recognition? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Arono. Aye. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis?
No.
Mrs. Blackburn?
No by proxy.
Chair Durbin?
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
Nomination will be favorably reported to the floor. Next, we consider S 1979, Protecting Older Americans Act, which will prevent employers from enforcing pre-dispute arbitration agreements when workers bring an age discrimination claim. This will give victims a choice of whether to pursue their claims in court or through often secret, sometimes unfair arbitration proceedings. Last Congress, the committee had led the effort to end forced arbitration in cases of sexual assault and sexual harassment. With Ranking Member Graham's ending forced arbitration of sexual assault and sexual harassment, now the law of the land, survivors finally have regained their day in court, and misconduct that had been concealed from public view for too long has finally been brought to light. But claims of sexual assault and harassment are not unique in the way perpetrators use forced arbitration to conceal wrongdoing. Last month, this committee heard testimony from Joanne Grace, I remember it well, a nurse and patient advocate with almost 50 years of experience. Joanne faced persistent age discrimination after the healthcare system for which she worked changed ownership. She is not alone. According to an AARP survey, 78% of older workers have either seen or experienced age discrimination, and 1 in 5 older adults say they had personally experienced it since turning 40. But when Joanne and others like her try to bring their age discrimination claims to court, they're often forced into secret arbitration proceedings where the deck is stacked. In Joanne's case, her former employer couldn't even produce a contract or other agreement where she supposedly agreed to forced arbitration. Instead, they claim she attended a training about arbitration and as a result couldn't bring her claim in court. Older Americans who face age discrimination have a choice of whether to bring their claims in court or should have that choice, or pursue arbitration. During the committee's April hearing, Victor Schwartz, who otherwise touted the benefits of arbitration, testified, and I quote, "Age situations are different than other claims and that different rules should apply." Most members of this committee seem to agree with that statement, so I hope we'll be able to come together and agree today, as we did for the claims on sexual assault, and end forced arbitration for cases of age discrimination. I'd like to turn to one of the lead sponsors of the bill, Ranking Member Graham, for making any remarks he deems appropriate.
Thank you. I want to thank Senator Gillibrand. We've worked on this for a while, but everybody on the committee has been great. We can always make the bill better. I'm open to doing that on the floor. I think there's a need out there to change the law because the playing field is so unlevel. More and more Americans in the workforce are aging, and I just want to make sure that if they feel like they're wronged, they can have a place to go make their claim that's more fair. Open up the American courtroom. They got to prove their case. I think the need is there, and to the committee members who've worked with me and others, thank you. I think in our small way, we're making a big difference to people who need some help. Thank you.
Thanks, Senator Graham. The floor is open for comments or amendments.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, I voted, I guess it was last year, for the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, because I do believe that there should not be anything that you might call forced arbitration. I do believe in the freedom of contract, however. And I know in visiting with Ms. Carlson, her concern was about forced arbitration. And the reason I voted for that is because I did feel like it fell within the ambit of what Senator Kennedy called contracts of adhesion. That is, not truly negotiated, but basically a take it or leave it proposition. But about 100 years ago, I was a district judge in San Antonio, and I remember when Chief Justice Berger said the cost and time consumed in litigation was as an effective bar to the courthouse as a padlock and a lock on the front door of the courthouse. Basically what he meant, and what I think still pertains today, is that for average Americans, they simply don't have access to the right to a jury trial in a court, not because they don't have the merits on their side, but because it costs too much money. and it takes too long. It's simply they can't afford it. So the only people who can afford it are Fortune 500 companies, people perhaps with a catastrophic injury that can agree to a contingency fee arrangement, which basically then plaintiff's counsel uses to finance the litigation and takes their fee out of any recovery, settlement, or judgment. I'm fine with that. I think those are an opportunity to get access to justice. But for many people, especially when relatively small amounts of money are in dispute, you can't hire a $1,000 an hour lawyer to litigate a $500 dispute. And basically, there is no access to justice short of something like arbitration or mediation. So back when Chief Justice Berger talked about alternative dispute resolution, that was the umbrella under which all of this fell. He said there needs to be some alternatives to ordinary litigation for people who want access to justice, who simply would otherwise be barred from justice because of the cost and delay associated with ordinary litigation. So my concern is that while I disagree with forced arbitration for the same reason I do believe contracts of adhesion should not be enforced, I do think that where there is freedom of contract, that parties ought to be able to enter into an agreement to resolve their differences through arbitration. And so I'm concerned that this bill is a blunt instrument that seeks to achieve a certain outcome, which I agree with, but I do think there are consequences that I think should cause all of us concern. Obviously, victims of age discrimination should have access to justice like everybody else. But I also note that this could well be a slippery slope. I know how things work around here. Once the precedent is established for sexual assault and sexual harassment cases, then the next case is age discrimination. The next case will be something else, which will necessarily appeal to our sympathies and concerns. But I don't want to see us throw the baby out with the bathwater and eliminate the ability to contract for alternative dispute resolution, because that may well be the only way that people of ordinary means can ever have their disputes resolved, through freedom of contract and agreement to go to something other than a full-blown jury trial with 12 jurors. That's, as I said, as an effective a bar to justice as a padlock and a chain on the front door of the courthouse. So I will not be able to support this bill in its current form, but I look forward to continuing the conversations with our colleagues to figure out how we might try to address this in a surgical manner. Thank you.
Thank you, Senator Cornyn. Senator Whitehouse.
I think I agree with Senator Cornyn that when big corporations agree after negotiations with each other to arbitration, that's a choice that they get to make. It's a very different thing when big corporations force standardized contracts where there is no negotiation onto employees and customers. In that circumstance, they do their very best to put themselves in the best possible advantage with regard to their employees and customers. And they do so, I believe, in violation of a fairly basic part of our constitutional system, the Seventh Amendment. And I hope that we get this bill out of committee. I hope we get it through the floor. And when we do, it will be a good day for the Constitution and the Seventh Amendment.
Thank you very much. I have an amendment that I'm going to withdraw, but let me say at the top how grateful I am for Senator Kirsten Gillibrand and Senator Graham and others who've worked so hard on this legislation. It's an extraordinary example of people coming together and getting some good things done. I want to thank a lot of outside advocacy groups, people from both parties, American citizens who've stood up and made this their cause, having gone through awful experiences themselves, have helped to drive this change. I want to note that Gretchen Carlson is here and how grateful I've been for her leadership under very, very difficult circumstances to speak out with such clarion call and such clarity about issues of discrimination. One thing again, I think Gretchen's become a sort of a hero in my office is because she just makes it plain. Discrimination is discrimination and it's wrong. What we've seen happening in workplaces, it's not the norm. Most companies in my state are really good companies that try to create really good cultures, but when it happens, it's just god-awful. And I know that my colleagues on both sides of the aisle just deplore that, the kind of awful, demeaning, degrading things that sometimes go on are awful. And the way things have, people being forced into these arbitrary proceedings in which they have to sign away their voice, have gag orders put on them, it is so deeply unfortunate and unfair to those individuals who now have very little rights and get very little restitution. And one of the most significant harms, though, by forced arbitration is that it obscures from public view how pervasive workforce discrimination can be in some environments. It gives employers cover, and in doing so fails to ensure what our justice system with its transparency often does, is that cultures change, environments change. When employees who have been discriminated against have no recourse but to go into these clandestine proceedings of forced arbitration, there is no sunshine on how pernicious this kind of discrimination is, destructive it is, and when companies settle these claims and get their gag orders, they go about their business. Now, the arguments against this, I heard it. Some folks were saying that, oh, if we pass this ending forced arbitration against sexual assault and sexual harassment, there'll be all of these frivolous lawsuits that are brought up. There's so much doom and gloom that was predicted about how awful this would be. And here we are 2 years later, the act was 2022, and we haven't seen that. What we have seen is that people who've experienced awful types of injustice and sexual discrimination have had justice. And now we're stepping up the plate and saying sexual assault, heck, discrimination is discrimination, and older Americans experience discrimination as well. And here we are in a bipartisan way, like we should, like I know the hearts of some of my colleagues on this side of the aisle say, together, this is wrong. We've heard from people, it shouldn't happen. But I don't understand why we are stopping. Why aren't we just saying any type of discrimination, religious discrimination, racial discrimination, age discrimination, sexual discrimination is wrong? And so this bill is a one step on a justice journey. But a step is not justice for employees in America. There should be a level playing field for any employee that encounters any kind of discrimination. So I am happy to support this. I am happy to go forward with this, but there is a sadness in my heart. But why are we excluding race discrimination? Are we saying it's not a problem in America? Are we saying that there aren't people suffering in silence or cultures that persist or people forced into gag orders because of discrimination against race? Because I know that's not what we're saying, so why stop? I hear the stories. My office has held the meetings with people who have had most disgusting, vile things happen to them, like folks who've suffered sexual discrimination, and yet they have no recourse and no justice. So this is a good day for America, but in many ways, when it comes to issues of race, we are failing to have constructive conversations that belie the politicization of racial issues in our country and just get back to the real understanding. When there's a harm, there should be pathways for justice. Where there is discrimination, someone should have their say and have their due. Where a culture of discrimination persists, we should end it. We have done this now about to be twice. I'm praying and hoping that the partners on the other side of the aisle and this side of the aisle that were so in favor of gender discrimination and age discrimination will now continue the effort and do the same for another type of discrimination we all know exists, and that's discrimination on race. Thank you, Mr. Chairman. I withdraw my amendment.
Thank you, Senator Booker. Anyone else seek recognition to speak or offer an amendment? there are no more amendments, we'll vote on final passage. The clerk will call the roll on S 1979.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal. Aye. Ms. Sorono. Aye. Mr. Booker.
Aye.
Bill will be favorably reported to the floor. If there's Senator Ossoff.
Thank you, Mr. Chairman. I'm so pleased that the committee has moved forward on a bipartisan basis to advance this legislation. I'm grateful to you and Ranking Member Graham for your leadership. And just so that my constituents in Georgia know what we've just done, we've just advanced landmark legislation to ensure that older Americans who face age discrimination in the workplace can have their day in court. It is a great day for the Judiciary Committee, and I hope that the whole Senate will take up this measure as soon as possible. Thank you, Mr. Chairman.
Thank you, Senator. Anyone else seek recognition?
Yeah, just to explain my vote, I want to associate myself with Senator Cornyn's comments. I learned a very valuable lesson by passing a major bill out of committee without getting some of my concerns addressed. It was called the PACT Act, and we needed to have a few other things worked on. I was one of only a handful of people that voted against that bill, mainly because Camp Lejeune Toxics was not ready for prime time, and now we're seeing people charged absurd amounts for legal fees. So I hope that we can get this done, and more importantly, not only get it into the Senate chamber, but do the work that's going to be absolutely essential to get it out of the House.
Thank you, Senator Tillis. Anyone else seek recognition? If not, the Senate Judiciary Committee stands adjourned.